Dr. DiFabio's evaluation of the defendant's competency raises serious legal concerns. At the heart of the matter is her qualification to conduct such an evaluation. California law is crystal clear on this point. Penal Code Section 1369 explicitly states that only those with specific forensic training and certification can determine a defendant's competence to stand trial. Dr. DiFabio, a licensed clinical psychologist, does not meet these stringent requirements. This is not a mere technicality. The law recognizes the specialized knowledge and expertise required for forensic evaluations. In People v. Superior Court, Marks, 1 Cal 4th 56, 1991, the California Supreme Court affirmed the importance of adhering to these qualifications. The court held that allowing unqualified individuals to conduct competency evaluations would undermine the fairness and integrity of the legal process. Dr. DiFabio's lack of forensic credentials immediately casts doubt on the validity of her entire evaluation. Her evaluation should be inadmissible in court. The court should appoint a qualified professional to conduct a proper competency determination. The defendant's rights and the pursuit of justice demand nothing less. It is important to note that clinical psychology and forensic psychology are distinct disciplines. While clinical psychologists focus on assessing and treating mental health conditions, forensic psychologists specialize in the intersection of psychology and the legal system. They undergo specialized training in areas such as legal competency, risk assessment, and malingering detection, making them uniquely qualified to conduct competency evaluations. The brevity of Dr. DiFabio's evaluation is simply staggering. A mere 37 minutes is utterly insufficient to assess a defendant's competency adequately. The legal standard established in Dusky v. United States, 362 U.S. 402, 1960, requires a comprehensive examination of the defendant's ability to understand the charges against them, the legal proceedings, and their capacity to assist their attorney in their defense. This necessitates a thorough evaluation that extends far beyond a cursory interview. Competency evaluations typically involve hours of testing, interviews, and observations. These evaluations are comprehensive. They delve into the defendant's mental state, their understanding of the legal system, and their ability to work with their attorney. A 37-minute evaluation is therefore not only inadequate, but borders on the absurd. It makes a mockery of the legal process and raises serious concerns about the reliability of Dr. DiFabio's conclusions. The Dusky Standard is a cornerstone of our legal system. It ensures that defendants are not forced to face trial in a state of incompetence, unable to understand the proceedings or assist in their own defense. By conducting such a truncated evaluation, Dr. DiFabio disregards this fundamental right and potentially jeopardizes the defendant's right to a fair trial. Dr. DiFabio's diagnosis of unspecified bipolar disorder is equally troubling. The diagnosis lacks the necessary rigor and supporting evidence required in a legal context. In Cell v. United States 539 U.S. 166, 2003, the Supreme Court emphasized the importance of reliable and valid diagnoses in competency evaluations. The court held that diagnoses must be supported by comprehensive psychiatric assessments and not based on speculation or incomplete information. Dr. DiFabio's cursory evaluation falls far short of this standard. A competency evaluation is not the appropriate setting for rendering a formal mental illness diagnosis. Such diagnoses require a thorough psychiatric history, clinical interviews, and often, psychological testing. Dr. DiFabio's reliance on a brief interview and limited information casts serious doubt on the accuracy and reliability of her diagnosis. The potential consequences of an inaccurate mental illness diagnosis in a legal setting are significant. Such a diagnosis could influence the court's decision regarding competency, leading to inappropriate treatment or even involuntary commitment. It is crucial that any diagnosis made in the context of a competency evaluation is based on a solid foundation of evidence and adheres to established diagnostic guidelines. The final nail in the coffin of Dr. DiFabio's evaluation is the lack of a signature under oath. This omission is not a mere oversight. It is a blatant violation of California Evidence Code Section 710. This code explicitly states that expert testimony, including reports, must be made under penalty of perjury to be admissible in court. The purpose of this requirement is clear: to ensure the truthfulness and reliability of the evidence presented. In People v. Sanchez, 63 Cal. 4th 665, 2016, the California Supreme Court upheld the importance of sworn testimony, emphasizing that it allows for cross-examination and challenges to the expert's credibility. By failing to sign her report under oath, Dr. DiFabio undermines the integrity of her evaluation. Her report becomes little more than an unsubstantiated opinion, lacking the legal weight and credibility required for consideration in a court of law. The cumulative effect of these violations is damning. They paint a picture of an evaluation that is not only legally deficient but fundamentally flawed. Dr. DiFabio's actions raise serious concerns about her professional judgment and cast a long shadow over the entire evaluation process.